accountant MSD করতো I দেখতে পেয়েছি একজন 5 next year hospital big her pan finally মেকামে একজন for 2
Mr.
DLE
Diali.
E
Diali. And it's from being for the being on behalf of the how much time?
2 weeks my
2 weeks. So we have informed the RFI.
yes ma'am.
The submitted that consent.
They can mention item number 7 of supplement. Let me state some instructions required from the petitioner and for the petitioner. We have not received similar and some timing and some
Or what time?
they can mention item 2 Rashid. Rashid, can you please send it to me? K Khan.
We can't. Given for
2 weeks.
May I please have it? Rashid, I'm paying for listing for a motion lot here. The paying for listing
yes,
motion
when?
and on 8 lot.
8. 8 is what? 8. 8 is Sunday. Sunday.
9.
Public legal it mentions item number 4 my
4.
can it be taken up in the next few minutes and for the petitioner anything 12 or 26
26 already we finished
20
the week was done. Particular. Okay.
May I please have lot. Rashid, listing for a rate petition lot.
In which column?
6. Rashid plus Waters column.
Huh?
Waters column, Rashid. Waters column.
daily list for admission item 1 but the petitioner has been allocated to works as per tender notice case 32 from page 24 onwards the tender notice and accordingly works has been allocated to the petitioner
32.
Page 24 onwards,
24.
24 and 32. Lordship, got it?
Yes.
Thereafter, Lordship, work order has been allocated to the petitioner, page 40. On 24/9/2007.
Oh,
Annexure 3.
yes.
Lordship, it has been allotted on 24/9/2007. And time of completion is 4 months. Clause 4. Next work order, Lordship, will find at page 42.
There are two works or what?
Two works from the same department, Education Department. Page 42, next work order, dated 14/2/2008. And period of completion is 90 days. Clause 4. Time of completion is 90 days. Petitioner has completed both the work, page 44. Page 44, may I read, Lordship? This is certified that Chandan Deka, contractor, Bochisto Sarli, Amritnagar, has completed the construction work in all respect and he has no liability against the work. Umati Iman, F. Value Iman, dated 31/8/2007. Work order value Iman. Completed in all respect. Next work order also completed, page 45. Dated 14/2/2011. Both are same date. Thereafter, payment has not been released. Petitioner has approached this Honorable Court, page 46. As per Lordship Tamsir Ali's case, directed to pay the amount. Page 46 is the order. Thereafter, Lordship, they have not paid the amount. Petitioner has filed notice has been issued to the page 50.
What is page 48?
Page 48 is the next order approaching the same case, and there is a direction Tamsir Ali.
Okay.
Both they work separately. It has been done. That is why two orders. Hereafter, Lordship, the petitioner has communicated the order, page 50.
Yes.
Hereafter, advocate notice has been issued at page 51. Thereafter, Lordship, the principal secretary, Karbi Anglong, in 2012, communicated to the order to the executive engineer, Karbi Anglong Division Irrigation, with reference to the above and continuation of the Iman, I am directed to request to kindly submit the proposal as per order of the Honorable High Court in respect of payment of outstanding bill of Chandan Deka, Sonnab Uttam Deka, Nagar Iman. This is for your payment necessary action. That is written by the Principal Secretary, Karbi Anglong Autonomous Council. Hereafter also, they have not paid the amount. Petitioner again communicated by letter dated 24/9/2014. Hereafter, also, petitioner has filed a contempt petition, that is contempt case number 366 of 2012, page 56. Lordship got it. Now, Lordship, the contempt petition was closed on the basis of undertaking by order dated 2/2/2025. Lordship will find the relevant portion, page 58. Karbi Anglong Autonomous Council not being a part of the petition, impeding said council is contempt petition is untenable. However, contemners who are party to the writ petition have given undertaking regarding making payment as per the direction of the Honorable Court have stated is. They have given the undertaking on the basis of this contempt petition has been closed. In view of the above, petitioner are closed with liberty given to the petitioner to be filed press contempt petition if amounts are not paid as per undertaking. Relevant portion, Lordship got it, page 58.
Part payment,
No.
huh?
No. Some payment has been made, part payment. Remaining payment.
Yes.
Hereafter also, they have not paid the amount, though they have given undertaking in 2015. Petitioner have to approach this court again. 1070 of 2016, page 59. Lordship got it. Same thing has been discussed in the order. And finally, petitioner also paid for interest on the amount. And this honorable court, regarding interest, it has been held at page 64. Relevant portion. Page 64. From para 10. Regarding interest portion, liberty has been given to approach the civil court. Appropriate forum.
Para,
Para last portion, para 10 is the prayer for interest of the amount. And last portion is 11. Prayer for interest was rejected. I have to approach the appropriate forum for delay in making payment. And there is a order for joint verification also. Para 9, last portion. Para 9, last portion.
What is joint verification?
Joint verification
Some
regarding
mention
the
is
site
there.
and the
I have heard.
Lordship got it. Under the circumstances, in my opinion,
Joint verification. Let us read paragraph 7.
paragraph 7. I have heard learned counsel, background of the claim made by the petitioner as referred above, respondent of filed additional affidavit on 23/7/2019 and place on record joint verification report dated 25/9/2018 carried out jointly by
What
the
is the
petitioner.
source of this joint verification report?
Lordship, I have obtained the joint verification report under the RTI Act. I'll show that.
No, who directed?
Court directed.
Where?
In earlier, Lordship, the order, there is an order that has
Where
not
is
been
that?
annexed. The direction from the court.
How this PIL has come?
Lordship,
How this PIL has come?
Lordship, the
What is this PIL? High Power Technical Committee?
Lordship, there is a PIL, as per instruction my junior Lordship, that contractor some approach that honorable court, that contractor bill has not been paid. And the other, this court has directed in the PIL to pay the bill in, Lordship, as per the work completion report.
Come to page 63.
Page 53,
63.
Lordship.
in between, first paragraph.
In between PL
7,
107 of President
Ah.
was filed before this court, and this honorable division bench of this court constituted high power technical committee to visit the site in order to examine the matter and submit opinion in respect of the financial irregularities, if any, committed in execution by education scheme. It is further stated that rupees 5 lakhs was paid to the petitioner.
So this, the side means this side, petitioner side, two
No, no,
sides.
no, no.
Huh?
That was commanded.
Because prior to that, joint verification, something like that.
Can take a printout of the PI order, Lordship.
This joint verification report has any connection with the PIL?
No, no, no.
Huh?
This joint verification has
It
been
looks like page from page 63.
page 63.
Looks like that joint
Petitioner
verification
has filed
report
additional
has some
affidavit.
connection with the PL and also the contract works involved here. Because he has reproduced paragraph 7. PIL was closed after accepting the report of the High Power Technical Committee.
There is a- And joint verification report I have annexed also.
The sequence of events not function. Because undone.
This is lots of PIL regarding different works. This is regarding Dilangti education scheme. Give me.
So this petition was disposed of directing the respondents to take note of the joint verification report and on that basis a fresh assessment.
Assessment.
Yes.
Also, I have also annexed the Tamserali judgment that is not required. Lordship is aware. Page 66, Tamserali judgment and Jotin Pathak regarding release of page 66 and onwards, Tamserali's case has been enclosed. Lord. Thereafter, contempt case again has been filed, page 80. And same is pending till date. Close karen.
Now, come to page 64 again.
Lordship,
This direction. That is only material.
Lordship,
Now, what did they do?
that's issue. I have applied under the RTI regarding the joint verification.
No, in the present writ petition,
Lordship,
is there any counter?
counter has been filed.
What they speak about this part of the direction?
Lordship, they have stated that the work was not completed now and they could not find this certificate issued by the competent authority in their record was damaged. That is the reply. And Lordship will find the RTI
Phrase
reply.
assessment. Where is the phrase assessment?
Page 93, I have obtained the RTI information.
Page 93.
And 94 is the information.
Page
Page 94 is the information.
uh,
They said repairing is needed to the scheme. Therefore, balance amount of rupees demand.
where is the phrase assessment?
Page 96. Page 96.
What is this page 96?
Page 96 is the Lordship, they have deduct balance amount to be paid, deduction repairing of the scheme.
Total outstanding bill value.
And thereafter deduction for repairing of the scheme as per Honorable High Court's verdict.
Which one is verdict? 3/9/2021?
Page 63, Lordship.
There is no mention of any deduction.
Deduction for repairing of the scheme as per Honorable High Court order. This is the deduction.
Where is the direction for
Direction was not there.
deduction?
That is why we have approached this Honorable Court.
Amount paid March. Till I have not understood page 96.
96, they have said deduction repairing of the scheme as per Honorable High Court verdict. There is no order from this Honorable Court for deduction any amount after joint verification.
What is last but one column total deductions?
Total deduction made.
What is this figure is somewhat out of the blue? What is this?
This is Lordship. মাইনাস করে চলে বলে
This guest house is not part of the.
no.
Yes, what is the stand regarding face assessment?
Price assessment, Lordship will find page 64 of the order dated 3/9/2019. Para 9 last portion,
That is what we are examining
Lordship.
only.
Okay.
Where is the face assessment?
Page 98.
98 is verification record.
Lordship,
See,
verification.
by common order, thereby directing the respondents to take note of the joint verification report. That is 98.
98.
And on that basis, a fresh assessment be made.
Lordship.
So where is the fresh assessment?
Lordship
You
will find
take note of joint verification report, then make a fresh assessment. That is the direction. We cannot expand the scope now. Where is the fresh assessment?
price assessment is 96.
This will be part of the consideration. Joint verification report, whatever comments they have made, right?
Lordship.
And that was in 2018,
Lordship.
whereas the work orders of 2007 or 8 or 9, after 10 years,
After 10 years.
right?
Okay.
Where is the fresh assessment?
Price assessment has been given at RTI information page 96.
Oh, Mr. This cannot be without giving some figures here in a table. Cannot be a fresh assessment.
I have not
This
been
is not,
communicated, except that I have not communicated anything. My case is, Lordship,
no, your case, but whether they have complied with the direction. That is a intra-party order.
Lordship,
Is there any affidavit?
affidavit has been filed.
Let us see the affidavit.
Lordship, before that, may I submit one thing, Lordship?
I have understood your case.
Lordship, I have completed the works.
That is already there. Let us see whether assessment has been made according to them.
Their affidavit, Lordship will find they
Let
have
us
not
see
any.
their affidavit.
Page 109, Lordship, their affidavit.
What they say about completion certificate?
They have stated. Para
Regarding completion certificate first.
Page para 8, 113.
Para
8, 113.
8. Let us read from paragraph 7.
Lordship. Deponent beg to state that work for execution of head works was issued on 24/9/2007. Petitioner thereafter submitted running bill for the works purportedly executed on 2007 and 2008 and claimed the entire contract value of rupees Iman. Petitioner, by submitting running bill, could not have legitimately claimed the full value of the contract, particularly when it is highly improbable that the entire work would have been completed within such a short period of span of time.
Their work order says four months and one is 90 days. Now, this is 1 year. They think that engineer now thinks that it cannot be completed within such
Short period.
short span of time.
And it was completed in
Yes.
2011.
They prepared a work order,
Lordship.
then
Then,
8.
para 8, deponent begs to state that a work order for construction of the head works, including diversion work, Pathakandi Iman amount, was issued to the petitioner on 14/8 The petitioner thereafter submitted bill showing work purportedly executed on 15/2008, 15/6/2009, claimed the entire contract value, which casts serious doubt on the quality of genuineness of the work. As
That was 90 days time,
90 days ties.
90 days time. And this was four months time.
Lordship.
Now,
Completed in 2011.
so this engineer must be, his qualification is in doubt then. He prepares the DPR. He invites the tender. The time of completion be 4 months and 90
90
days. Then when the contractor completes, then he doubts it. How can it be complete? Within 4 months.
4 months.
15 to 2008 to 15/6 means 4 months. The period was 90 days. Now he says, how can it be? Yes. What is this? Man is saying,
My
you
lord,
prepared a work order
my
and
lord, my
give the
lord.
time
That
for
is the
completion
particular-
90 days.
my lord,
The contractor completes it within 4,
months,
months.
my lord,
which means 120 days.
my lord.
Now, how can he doubt?
My lord, maybe, my
this-
lord, that there is no explanation on that, but there may be the whole entire work, not, that is of the part of the work, whole irrigation scheme. He may mean it by that way, that whole
Whatever,
irrigation
that-
scheme,
Maybe
As
there
a-
may be 100 schemes I have
my
seen.
lord. Not in that
But
particular
question is
scheme,
one particular work.
My lord.
He gave time,
my
90
lord,
days.
my lord, my lord,
He should have said that, yes, why you have delayed by 1 month?
my lord,
O-
that is,
On the contrary, he said, how can you complete?
my lord, that as the, my lord, the work has not been completed properly, my lord, to the satisfaction of the authority, my lord.
Then
it
who
is
has
certified.
issued, what is the doubt about completion certificate?
My lord, the completion certificate, if your lordship look into it, there is no office memo, there is nothing
Right.
like that way.
But
And as
are
per the,
you
my lord,
saying that it is a full
Shamsher
block?
Ali, my lord, as per the, my lord, the head of the, my lord,
Then
my
you,
lord,
after 10 years, 18 years, don't take that plea now.
my lord, My lord,
Right.
so
Whether
we are
you have
not-
said that it is a
no.
forged one.
my lord. So we are not taking that plea, my lord.
Whether it is
We
a
are,
forged,
My lord.
those completion certificate forged, have you taken the plea?
no, my lord, we are now, my lord, in this case, we are not taking that plea, my lord. In this case, our case is that case assessment, reassessment was made. And after
What
that,
is that?
my lord, Trace, that record is with me, my lord.
No, no.
What is no, we have not annexed that, my lord, how the place,
How can you do so?
my lord, as
Court
per,
direction is that intra-party.
my lord.
You cannot do it secretly.
No, not secretly, in the presence of the petitioner, my lord. Joint
Whether he has
verification,
been given the phrase assessment report.
but how
See,
the
it
place
is an
estimate,
intra-party order.
my lord,
Page 64.
my lord, my lord,
Is it not?
my lord.
Then
That- I can, my
see,
lord, by way of
it would be
additional,
proper to dispose of both these writ petitions by a common order, thereby directing the respondents to
Hmm.
take note of the joint verification report.
my lord,
And on that basis, a fresh assessment be made.
my
And
lord.
thereafter, necessary payments shall be made.
So,
So first is a fresh
now, first, my
assessment
lord, joint
report.
verification, first, my lord, joint verification report,
That is already in existence.
my lord,
Right?
my lord,
On that basis,
My
fresh
lord.
assessment.
my lord,
That has to be
done, my lord,
done and to be communicated.
my lord,
It is inherent there.
my lord,
Then thereafter the
My-
payment.
my lord. Then the,
Otherwise, if fresh assessment,
my lord,
the principle of natural justice,
my lord,
he should also be communicated with the fresh assessment report.
my lord,
On what basis? Because you cannot pick up
my lord, my lord,
a word from the
my lord,
cloud and put it in a page 96 calculation.
my lord,
Done. So no money.
my lord,
Oh, how can it be?
my lord, my lord,
This man is a responsible man
My
or
lord,
what?
my lord, on the basis of the joint verification report, my lord, reassessment was made and whatever the amount is
You
required to
have
pay, that
done
has been
joint
paid.
verification.
My lord,
No, that is now it is a question.
my lord,
Where is your measurement book?
my lord. It is,
Where is your measure? Produce.
a measurement book is
Ah.
also, should be also be there.
There must be engineering charge.
Yes, my lord, my lord.
Where is the measurement?
MB is there, my lord, they have that, what is the, my lord, estimate that has been prepared, my lord, that I have not annexed in the yet, but that is in the record. I can bring it on record how the reassessment has been made and if,
Reassessment.
my lord,
At this distant.
and the original record,
Mr.
MD also, my lord,
Sutia, at this distant point of time,
my lord,
work order was
of 2007.
2007 or 8.
Oh, my lord. 18 years has been passed.
Purported completion certificates were issued in 2011.
11, my lord.
Right.
My lord.
And this is a irrigation scheme
My lord.
which faces the wrath of nature
My lord.
and mighty river.
My lord.
Right.
My lord. My lord.
And you carry out in 2018.
18, my lord.
Right.
My lord.
Think yourself.
Yes, yes, my lord. I understand
What
fully, my
could
lord.
be?
So I understand fully, my lord.
It
That's
is
what
not.
is done, but
It is
so, my
not
lord,
Tasbal which
my lord,
which
under the
which
read
repels
jurisdiction,
all
my
the
lord, I know, I yeah,
forces
understand
of
all these things.
nature.
What is the case of the PIA? What is the, my lord? Yes, I understand all these things. Only I can it now submit it, my lord. It is mediation is going on. If both the parties, my lord, agrees to go to the mediation, if he decided they are, my lord, then it is under jurisdiction. What is our estimate? What is all these things? If the our additional petitioner and the petitioner is sitting, my lord, go to the mediation. If it can be decided, it is going on till 31-3, my lord. That will be better, my lord.
Mr. Goswami, better one
Better, my lord.
option
It is a better
better,
question.
because otherwise,
Otherwise, I will produce, my
again,
lord,
it would
estimate.
be,
I will
you
produce
look
the,
into, you look into Puna Hinda also,
my lord, I will produce the,
Supreme Court judgment. So, better to
My
have a
lord.
mediation,
that in our High Court judgment, that judgment go
Uh,
to the Supreme Court also, my lord.
otherwise,
And
My
Lordship
lord.
has already,
I have already spoken to
some
him
kind
also, my
of
lord, on that,
mediation
my lord.
might be successful. But you have to be.
Yes, my lord. Yes, my lord. I will instruct
Open mind,
properly, my lord.
otherwise,
My lord, I will instruct properly. I will look into the MBA myself, my lord. I will, my lord, will be in the also in the mediation center, my lord, if possible, my lord. Some, I will
find
properly
a
instruct, my lord.
reasonable solution to
My
it,
lord.
right?
My lord. And
Otherwise,
we have
you-
already informed him about that, whether he is interested to do the works, my lord. He refused to do the, my lord, repairing works also, my lord. So we have offered to him,
But did
that-
deduction,
my lord.
deduction
My lord,
was
after, my lord, 7
his
years,
comment.
and there is a flood
As
is
per
there,
the
my lord.
direction of the
My lord.
court, you deduct
Lordship is
97 lakh.
complete, lordship is completed, right? In some other cases, we have taken the plea that after the flood, my lord, in that many schemes has been damaged, my lord. So probably that one is also there, but that is also true. The petitioner has not completed up fully to the
But
work, my lord.
he
That
has
is
been
also,
claiming.
my lord,
That is why
my lord.
he has been
it
claiming
is
right
better to-
since
If your
2010.
lordship petitioner agrees, my lord, lordship, let it be sent to the, if it's pending, let it be sent to the mediation center, my
Okay,
lord.
better, at least he can have some, if a good reasonable amount, otherwise.
Yes, my lord. Yes, my lord.
There is another risk,
Yes.
if it goes into disputed territory again,
civil court.
another
Then
risk.
civil court, my lord. If you go to a mediation, if you, both the parties are sitting together, my lord, whatever amount, my lord, that can be
It works
decided, my
out
lord.
really well,
My lord,
because we are also handicapped in some
My lord.
manner.
my lord.
This stress assessment direction,
lord. That is, they are also with me, my
I
lord.
have to go by that.
My lord,
I cannot go beyond that.
my lord.
Joint verification report, yes, after 7 years or 8 years, whether it would be,
But as
in
per the direction
existence.
of this court, my lord, joint verification was carried out, my lord.
we don't know what.
My lord, that order has
how-
not been annexed. That order has
how-
not been annexed.
How, where
My lord, order is there, my lord. Order is there, joint verification report.
is it?
Is it, my lord?
Yeah.
The PLF, no, in this particular case, joint verification, there is an order from, for joint verification.
Where is that order? See, if it is.
I've not verified it, my lord.
If it was agreeable by the
Yes,
petitioner
my
at
lord.
that point of time,
My
then
lord.
another element.
My lord, lordship, I'll look into that
At
order.
a distant point of time, suppose you did the work in 2011, but in 2018, you have agreed for joint verification.
My lord,
but I have said,
It can be easily visualized
Ah.
that there will be nothing. Right? Had it been a building, say Deputy Commissioner's building or MMC hospital building, it would be in existence. Right?
but irrigation
Something could be assessed.
but irrigation,
Irrigation scheme, embankment. After 7 years, forces of nature, forces of river, you have agreed after 7 years. What would remain?
Lordship, as per
It will be
Lordship, I-
like
Lordship, I understand.
it will be like Harappa Mohenjo-daro.
As per agreement,
That is a problem,
Lordship,
and that is the problem for the court also. How can we assess?
Lordship, as
And
per,
it is state exchequer ultimately.
as per Lordship, the contract agreement, our guarantee is only for 90 days.
You should have tenant there.
There is arbitration clauses also there in the PWD
Yeah.
manual, my lord. So we are not going into arbitration mediation is similar nature, my lord.
Ah.
It can be, my lord.
When Mr. Chutia, your additional chief engineer can be present
Before the mediation
before the
center.
mediation. And when petitioner is from which place?
Lordship may fix a date, my lord. Any
Guwahati.
date, my lord. Any date, lordship may fix it. I will convey it.
Please tell me, we'll put the date blank. You consult your additional
I'll give the date.
hired Mr. S.K. Goswami, Senate Counsel for the petitioner, and Mr. J. Sutia, Lion Standing Counsel, Karbi Anglong First Council, for the respondent number 2-3. Miss D or B?
Yes.
DS, New Lion Standing Counsel. Irrigation Department for the respondent number 1, and Mr. J. Sutia, Lion Standing Counsel, Karbi Anglong Autonomous Council for the respondent number 226. Post. Para.
So did it.
Having regard to the issues involved, Mr. Sutia, the Standing Council KAC has submitted that the case may be referred to mediation. As in the নামটো আছে নামটো চাই দিব since the
There is a disputed question of fact.
we'll not go into that.
My lord,
We'll not record that.
the
Consciously will not record.
এটা লাগে তো
Ah,
আইকো রাইব
see.
লাগে
The special mediation drive
অলপ সময়
is
ফাইলত হেৰি কৰি
since
আজি কি
the
তাৰিখ হ'ল
mediation
4 তারিখ 5 তারিখ
for the nation. নামটো বেলেগ আছে
24 তাৰিখ দিয়া
is presently uh, two point zero again is presently being undertaken, and there is scope for mediation. And the respondent authorities in the KAAC are agreeable to explore the resolution of the matter through mediation, the case may be referred to mediation full stop. The suggestion made by Mr. Sutia, accepted by Mr. Tamil and counsel for the petitioner, full stop. Para. Married counsel for the parties, along with the concerned official respondent, shall appear before the mediation center on
24th one
24/2/2020. Para. Mr. Sutia, Standing Counsel, AAC, shall apprise the official respondent authorities in their about the first date of mediation so that the responsible officials attend the mediation process. Mr. Goswami, learned counsel for the petitioner, shall also communicate the date of date fixed for mediation to the petition. Para, office to list the case date after receipt of a report from the mediator about the conclusion of the mediation.
Lordship may observe premeditation can also be help. Premeditation can also be held. Counseling, premeditation counseling.
24 to premeditation.
উপৰত লিখি দিব, লিখিব next. For the purpose of further reference, the parties shall contact the coordinator stroke nodal officer of the mediation center on before that. Uh, 18 to
Oh, plus.
18 to.
Right.
You meet the coordinator, and if reconciliation,
Public.
better to in the
My lord.
midway
My lord.
via media
My
is
lord.
better.
There's a burden of lordship now. GST has given a bill of 10 crore rupees.
And Mr. Sutia, any presence of the irrigation department is necessary? Irrigation department.
My lord, ultimately fund will come from the
Okay,
irrigation
Miss
department.
Neog also.
A fund will come.
Miss Neog also, same, Miss Neog and Mr. Sutia. So that
lord.
ultimately the parts is with them.
My lord.
Three.
एक कागज এখন থৈ দি কিবা চাই ল'ব yeah
But before submitting my friend, my lord, meta may pass over for the day only, my lord. Next date, any date,
what is the matter about
my lord, the hiring of scraping wins, my lord.
tender matter
Tender.
challenging award of account okay
I am the respondent number 5, my.
Is already operating now. Has been awarded by list terms and conditions.
do you appear for
or owing this.
okay
I'm ready otherwise.
mm. If I remember correctly respondent number 5 I appeared earlier in 2 rounds respondent number 5 against ONGC. All this Article 366 ultimately Supreme Court had held. Mojika something last year. Series of litigation.
Yes, sir.
Better two parties. I should not take.
That I will.
In 2 rounds. Though I lost contact, but still everything is on
I-
paper. I'll not record anything. This is the case with many other bank. As the counsel for the parties have expressed urgency. Any urgency? No.
Yes,
Any interim
Actually, my
order?
friend has urgency.
Okay,
I guess there is no.
The counsel for the petitioner has expressed urgency. Please to this case. Explain. On a date. I'll not say anything.
yes.
A prayer.
Obliged, sir.
Supplementary list, item 8.
Where is Mr. Bora? Actually, big beef is difficult to handle. So Bora, it looks like
Facts are same.
facts are same.
Legal point is same, my lord.
Legal point is same. If legal point is same,
Yes, my lord.
this clause 5H, whatever, has been interpreted in a manner that product department should precede farm department.
Yes,
If that is so, after interpretation of these clauses, then there is directly product department here, farm department here, without there being department. And also that 90% as a whole, not as a,
not as per such order. Yes, my
that
lord.
is the principle laid down,
Yes, my lord.
proposition laid down. So in that case, it will be difficult to go in a different way.
Yes, my lord.
And this judgment, unless it is set aside or
Yes, my
reviewed,
lord, I understand.
it will be
Yes.
respected.
Yes, my lord.
That is a problem.
Yes,
Right.
my lord.
So what I intend to do, instead of we put it on, say, Wednesday, in the meantime, I'm looking into it, I'll direct the factual part.
Yes, my lord.
Sitting in court, directing it from
Yes, my lord.
if it is difficult.
Yes, my
Right.
lord.
Just tenders are good. Petitioner is suffering loss
So-
due to without.
If I reserve it, it might take 1 month.
Yes, my lord.
So better to have, then I'll continue dictation, then I'll fix it, get you. So as it is also for the court also. It is not that,
Lordship may fix it on
it
Wednesday.
is not that,
I'm sorry, Lordship may.
that I'll go by your word.
Lordship,
Yes,
It is my prerogative.
Lordship. I just prayed for Lordship.
That I know, that is why
Lordship.
that day I took
Lordship.
time for myself to read the judgment.
Lordship.
Yes, my
It
lord.
is not that I am not concerned with you. Don't make such submission. And still I said that so that it can be done early for that part.
Lordship.
I said that
Lordship.
so that I can dictate the facts properly without any correction.
lord.
So I put it so that it can be finalized by next Wednesday,
Lordship.
right? I can try,
Lordship.
and at best, if we'll put it on Wednesday,
My lord.
if not possible, then finally Thursday.
Yes, my
my
lord.
I'll try to make it possible,
Lordship.
Yes, my
Lordship.
lord.
because this, I cannot entirely quote the judgment.
Fine.
I have to take out the ratio and make it applicable in this case,
My lord.
right?
My lord.
So there is no instruction from you to challenge the judgment.
Not yet. Yeah.
Uh,
Yes, my
It has to be. এটা কাণ্ড। এটা দুটা বাজাতে ঠিক- তিনটা, right? But instead of putting it in a court,
Yes, my
My
lord.
lord. My.
the facts
Yes.
I'll draft.
Yes, my lord.
Facts at least to be drafted,
Yes, my
which will be shown to you on Wednesday.
Yes, my lord.
My.
Yes, my
Right?
lord.
Lordship.
Yes,
Thereafter, if any factual things are wrong,
Lordship.
yes, my lord.
then you do the correction.
Correction.
So far as the further direction is concerned, you leave it to the court,
My lord.
Yes.
right?
Lordship.
Because you have made my task difficult
Lordship.
by making such a big
Lordship.
on this.
My-
Dr. M. Sahewala, Learning Council for the petitioner, and the DP Bora Learning Standing Up Health and Family Welfare Department
Yes, my
for the
all the
response
response.
to stop. Release the case on so and so. Release the case again on so and so for consider Wednesday. Huh? Okay, I will start. I have some
Yes.
free time.
Yes, my lord. Oblige, my lord.
Oblige. my lord.
I'll sit at 2. Where is Mr. Sharma? Here's the records. Yes, Mr. Topadar.
I'm for R6, my lord.
Hmm.
Only 4 submissions to be made, my lord, at this stage, before my learned senior friends comes in. What I have understood from the pleading, my lord, they have challenged page 40 on the ground that
I'm just bringing the record, he's bringing the record.
Okay, let him make submission.
from their pleading, my lord, page 15, paragraph 16, my lord. In the second tender notice, my lord, they have not participated, my lord.
Hmm.
And then, my lord, once they are not participated in the tender process, my lord, 2 things they need to demonstrate. One is the arbitrariness. That will reflect from page 18, paragraph 22, they have mentioned, my lord. And then subsequently, they have also pleaded that I am not belong to the
Because
fishermen.
if he participates in the second tender notice, his challenge to the first settlement order would fall. That is also a legal proposition. If he participates,
Yes.
then he cannot turn back and say that first order of settlement was good.
I have well received, my lord, but the intention of the petitioner is, my lord, they have clearly demonstrated that they were under the bona fide belief that the interim order will continue. That will suffice to say that they were aware, my lord. Paragraph 16, paragraph, my lord.
1 minute. Where is the second settlement order?
Second settlement order, my
How
lord.
many bidders were there? The second. He says only one.
Only one. Second settlement.
Second
Second settlement.
Sing-
Three tender-
single bid, single bid,
Single bid.
single bid, my lord. Yes,
What is your clause in the single bid?
14.4, my lord.
Is the second tender notice is part of the
Oh, Lordship, maybe, I think tender notice is. Three tender.
Huh?
Three tender notice, subsequently 3 tender notice was floated, man. And then. Nobody participated.
It is not mentioned here, perhaps.
Finally, it was a challenge, challenged by lord, by another,
You-
Shahabuddin, my lord.
See, Mr. First tender notice was on 12/2/2021, February 2021. Is it not? First tender notice, where you emerged successful, was in February 2021,
Yes, ma'am,
right?
my favor.
Then settlement order was on 13/8/2021.
Yes, ma'am.
Then highest bidder withdrew.
Yes.
Yes,
Then you were the second bidder, highest bidder, so it was awarded to you. Then once Sahabuddin made some complaints, he was the third highest bidder. Just below you, he made complaints. Managing director, who is the settlement authority, he discarded those grounds of complaint and made the settlement order
In favor
on
of me.
13/8/2021, right? Thereafter, after 6 months, incumbent changed and it was revisited. And another order has been passed because you made a prayer that please exempt me from depositing bank guarantee. Right? So he examined that representation
Yes.
and decided to exempt you from the bank guarantee, at the same time, commercial prudence, according to him, demanded termination of the settlement order, right? And to go for retender. After that, how many tender notice there were issued? Mr. Sharma would be able to point out, because those are not in the record. His record. Finally, number of repetitions were preferred, right? Sahabuddin, similarly, petitioner also. Then retender notice was on 19/9/2022,
Yes, my lord.
right? And this impugn cancellation order was 8/4/2022.
This is under.
So in between
How many?
5 months, April to September. Was there any tender notice in between?
Two tender notice, my lord, the
Hmm?
22/6/2022 and 10.
Where have you mentioned? Mentioned?
Worship, 15.
Yes.
Worship, page 14, my lord.
Page?
Page 14, paragraph 15, my lord.
Page 14.
Paragraph 15, my lord. This is the second tender notice, my lord. 22/6/2022, my lord. And 10/8/2022, my lord.
Yes, admittedly, my lord, here in paragraph
According to paragraph
15.
15, two tender notices were issued and both were withdrawn.
Withdrawn, my lord.
Both were withdrawn.
Withdrawn, my lord.
So there was no need to
Last date, lordship. Page 40, regarding our speaking order. But
let me hear about the facts first. What is 5522? What is 5522? Annex 13. Annex 13.
Page 45. my lord.
Where interim order is operating?
First interim order is on page, my lord, the page 33, my lord, annexure 6.
Is 33.
Page 33, annexure 6, order dated 29/10/2021, my lord.
That was by you.
Me, my lord.
This page 46 was 10 tender notice dated 10/8/2022, right? Then there was a leave that the AFDC can go ahead with the tender process but shall not finalize, right? Without leave of the court. What happened there thereafter?
Hereafter, my lord, all the writ petition came for consideration on, my lord, 21/12/2022, my lord. And that day, my lord,
12/2022.
Annexure 14, my lord, page 61. This honorable court, my lord,
5552. WBC 5552. Five 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 two. 2022. X has jumbled up so many litigations. That you said that retender notice 10/8/2022. What happened thereafter?
nobody turned up. That's what I didn't. Nobody turned up, Lordship. No, in all the writ petition, nobody turned up. That record I have not got.
If that is also there, but so far 5606. 5606, that was oh. 4132. 55. All three.
All three.
All three. You mentioned two. What is this submission, Mr. Sharma? Come to page 64.
I have.
What is this? A representation has been redressed.
Was not opposed. Not there. It was not in the. It was not in. Keep an eye on. Opposed to the for proposal.
Maybe the new tender notice mentioned there is, I think, 19/9/2020. 19/9/2020.
Yes, ma'am.
That is a new development.
And
So other tender notice may be withdrawn. So, but why you withdrew your petition? Your challenge was to the
Lordship, when matter was came from consideration on 21/12/2022, my lord, this Honorable High Court recorded the submission and found that matter was infructuous, my lord, as because new tender process was not under challenge, my lord, and Honorable Court given liberty to challenge the new tender process. Hereafter, this present
but
petition was filed.
that was page 35. But there was a direction to maintain status quo. Interim order was there.
Yes, ma'am.
So it could not have been infructuous that those tender notices were in violation of the status quo. Your petition could not have been rendered infructuous.
Yes, my lord.
You
Because-
agreed to the submission. Is it not?
It's not our submission.
Your counsel, maybe Mr. Loskor was not there. Is it not? Your status quo order was operating,
Yes, my lord.
meaning thereby, because in the earlier also page 46, the court took note of the fact that an interim order was operating. Is it not? Page 46. An interim order is operating. Right. So in the subsequent process, say go ahead, but don't
Finalize.
take final decision without leave of the court. Right. So when 21
12,
2022 was there, so your interim order was still operating.
Still over.
And you said that, and that is why with regard to consideration of a representation has been redressed. What submission parties have made up, we don't know. 21/12/2022 order. By that time, retender notice dated 19/9/2022 came to be published.
Gotcha.
Then Mr. Loskos was there, I think.
Yes, my lord.
You were there.
Yes, my.
Then you said that the principal grievance raised in this writ petition with regard to consideration of a representation has been redressed. What is that?
After Lordship, page
After
40,
the
my lord.
impugn order, after the impugn order, page 40,
40, my lord.
did you file any representation?
The representation was considered, my lord, page 40, my lord. First paragraph, my lord.
That was disposed of
Yes, my lord.
in 21/12/2022 order. You have the order?
Yes, my lord.
Look at the order. The parties are in agreement, which includes you,
Yes, my.
that the principal grievance raised in these writ petitions with regard to consideration of a representation has been redressed and new development has taken place in the form of floating of a new tender process. Writ petition may be closed. With liberty to the petitioner to challenge a new process, if so advised. What representation was disposed of?
Which was filed for exemption of the bank guarantee, my lord.
How can it be? That was in challenge in the writ
Yes, my lord.
petition. Court did not give any decision till that. Only an interim order was passed. Right. So representation was for exemption,
Exemption.
but exemption was made at the same time settlement order was cancelled.
Cancelled, my lord.
You challenge it,
Yes, my.
right? In 4122 WBC.
122, my lord, challenge in this writ petition, my lord. Earlier I have not challenged, my lord. In this writ petition, my lord, I have challenged, my lord.
Which one?
In present writ petition, my lord.
Oh no.
Earlier I have not challenged, my lord.
Which one is, which you did not challenge?
Lordship, impugned cancellation, my lord.
84.
In present writ petition, I have challenged, my lord.
In the earlier one?
In earlier one, my lord, I have filed one, I have challenged, my lord, I filed one IA, lord.
No. The
By challenging, yes,
WBC,
sir. That order, my lord.
in WBC 5606, what did you? 5606 2021. So confusing. 2021. Huh. 5606/2021. What did you challenge? That order is there. This is MR Pathak. Uh-huh. Minute. Oh, you did not challenge 8/4/2022.
In this writ petition, my lord, I have.
Oh, how can now? I thought that it was in challenge in, you did not challenge.
After
You
giving
waited.
after giving liberty, I have challenged.
No, after giving liberty, that liberty is different. But page 40, when page 40 was issued, because so confusing, Mr. Sharma. 1 minute.
Lordship,
1 minute, 1 minute. So when status quo order was passed, 22, that status quo was extended or not extended?
Extended.
The- In F1 Fox. Oh no, so many facts are there, jumbled up. 5606/2021 or pass out. First order to pass out. So when 8/4/2022 impugn order, which one, page 40, was issued, cancelling the settlement, you did not challenge.
I filed one IA in 5606 by challenging that order, my. is not in record, my lord.
Huh?
This- eh,
Yes, Mr. Sharma, you might be there in all our proceeding.
Yes, Lordship, it was not there.
it was not here. I have challenged, my lord.
He, in the,
Without
in the court,
knowing you, I cannot say.
he, in the court, another counsel was there.
Huh?
Another counsel was, he told that he will file, challenge it, but he did not file it. But I remember.
Thereafter, which one you have selected? This one only.
Only tender.
Present tender.
That was the first one, 5606. And any other repetition? No.
No, my lord.
This is the one. Eight four 2022, when it was passed, it was not challenged immediately.
Remember, my lord, may be challenged in a.
It is not on record.
Not on record, my lord.
We don't know whether you have challenged it or not. You should have filed a contempt petition that my status quo order has been violated, or a new writ petition could have been filed. That this is completely wrong. This impugn order, I've been exempted. At the same time, my settlement order has been cancelled. It did not.
For withdrawal. Well, that was he agreed my and the by state council, you all I as a said he was agreed. Was one category. That's not under challenge. They have is bringing an IA or I will give party in this, and that was the sum. We all had with that's what last part my test of I was there as a party, but I was leading party.
Oril, Harry. Oril.
Court finding was categorical my that once the order is obtained, proposal of withdrawing for whatever reason, my lord, development or by the election and state council, that we are agreeing for withdrawal, my. In between, lot of change.
To challenge the new process. But but by that time the status quo operating that is gone. Now you said to challenge your name is there, I think SB Loskar.
Yes, ma'am.
Huh?
I
To
am
challenge the new process. New process means the tender notice dated 9/9/2022,
Yes, ma'am.
where you have now for the first time brought the challenge to 8/4/2022 in 2023. Is it not?
Earlier council, my lord.
Records does not reveal.
Yes, my lord. I will produce that. IA, my lord.
Any order was passed.
Yes, my lord. I will produce tomorrow, my lord. If
Any order was passed that yes, IA has been allowed to challenge. Is there
I was
anything?
also pending, my lord. I was also pending.
But any effective order has been passed.
Was
remember,
never,
my lord.
it was not on the record while
Record, my
passing the order, while that order, it was not before your lordship. Is the reason, actually, he could have said that let the IS would come.
No, at least you should have said that no, let this other to go. My case is based on violation of my earlier order of status quo. Because if the status quo is operating, then that 8/4/2022 order could not have been passed because it was status quo. That you have not challenged. Then that is waiver or acquiescence.
The earlier council, my lord, he has challenged my. lord, but-
Earlier, no, you have to step into his shoes. You cannot say earlier. It is petitioner. He may be represented by X, Y, Z, but the way the petitioner has projected his case is to be one. It cannot take resort to earlier counsel so and so.
I will find out.
That
my
is
lord.
not the way.
I will find out, my lord. no? Whether it was under challenge or not, my lord.
Because it is now some right has already been
Yes, ma'am.
accrued to
Yes,
the
my lord.
private respondent. Right. To disturb him at this stage is a serious issue.
Yes, ma'am.
Have you understood? A right has been accrued by the settlement order. And you want to challenge the new process. Right. Have you understood?
Yes, my lord.
Page 64, you said there should be a liberty. Now, new process cannot bring in the old one. Only new process. It should be limited to new process. In that case, the third prayer that is challenge to the impugned order dated 8/4/2022 would fall. If that would fall, then whether you have a case, you did not participate. Right? So new challenge to the new process, a party who did not participate in the case is not to be heard. What do you say to that proposition?
If one day maybe accommodation, make it part hard, my lord, I will.
I thought
find out,
that
my lord.
you had a good case. Now I think you had a bad case.
I will find out all things, my lord, produce.
I thought that you had some force that we'll examine on the basis of the records. Yesterday it was busy day, so I thought that I'll look into it. Now after looking into it, things are slightly small. Very small fact can bring in a huge difference.
We have not,
I thought that Tapadar may have a bad case. Right. Now it looks like that Prime Minister, you have a bad case. You took the liberty to challenge the new process. And now new process is the tender notice dated 19/9/2022. Right. Even he was a single bidder. Let us assume, otherwise single bidder should not have been accepted. Even if, but since you did not participate in a new process, so for challenging a new process, you cannot bring in an old order. Have you understood what I am trying to convey to you? Your prayer was before the court on 21/12/2022
Yes, ma'am.
was to challenge the new process. A new process cannot bring in the old process. And it cannot be said by mistake now.
The whole case. And whatever they will check. Now.
Hmm.
Iota of why they have not changed earlier.
Because at that time, when all the three repetitions came, because see page 46, at that time also submission was made that by Mr. Sahabuddin that an interim order was operating, right? And the senior counsel had rightly submitted, and Mr. Sharma also submitted that an interim order was operating. So court said, okay, go ahead with the new process, but without leave of the court, don't settle. Thereafter, when all the three petitions came together, that is why Mr. Loskar now that when three petitions, all three, you indicated only two. You indicated only two, Mr. Page 61. Facts should be said properly. 4122 and 06. But 5502 was also there. All three were before the court.
Yes, ma'am.
And you should have said, okay, let them withdraw the writ petitions. My writ petition should remain. And also I filed an IA for challenging 8/4/2022 order. That was not there. You withdraw with liberty to challenge the new process. Ek minute. 1 minute. 5606. মুখে দেখুন।
Lordship,
1 minute.
IAC bill number 51.
1 minute. 1 minute.
2022, my lord.
No order was passed.
IA, my lord, 513/2022.
এটা হেৰি ষ্টেপল মাৰি দিব।
IAC bill 513/2020. 513. In this IA, my lord, impugned cancellation order was challenged.
No, 513 is seeking impleadment. Seeking impleadment of the by the IA is by Sahabuddin only, not you. 513 is by Sahabuddin. Sahabuddin is not here now. That was by Sahabuddin in your writ petition, seeking his impleadment as a party respondent. So we'll proceed then on the basis of the facts presented, because this court will rise at 3:15 for the so and so. But this order has to be passed in your presence, otherwise my facts will be, my facts will go topsy-turvy. Yes. Whatever could be completed would be completed today, and it will roll over. Because facts are very difficult. Invoking the extraordinary and discretionary jurisdiction of this court under Article 220 of the Constitution, the petitioner has preferred the present petition with the following prayers. Page 20. 22 আছে গোটেই para. From the prayers, comma quoted above, it transfers that the petitioner has assailed an order dated 8/4/2022 passed by the respondent number 2, whereby and settlement order dated 13/8/2021 passed in favor of the petitioner, society settling a fishery, comma, Baiya Bill Fishery, BAIYA, fishery, pursuant to a tender notice dated 02/2021, dated 12/2/2021, had been recalled. So the petitioner has also sought for a direction to the respondent authorities in the Assam Fisheries Development Corporation Limited, AFPC for short, to give effect to a settlement order dated 13/8/2021 without requiring the petitioner's society to deposit any bank guarantee. And by executing the necessary contract agreement, full stop. The petitioner has also sought setting aside of an impugn, setting aside of a letter of where is it letter? 4/11/2022. Q1. An office letter dated 4/11/2022 of the respondent number 2 and addressed to the respondent number Mr. Topadar, you are for which one? Respondent number 6. Whereby it was proposed to settle the fishery in favor of the respondent number 6. For a period of 7 years. from the year colon 2022 dash 2023 up to the financial year 2028 dash 2029. The petitioner has also sought setting aside of a deed of agreement which the respondent, which the respondent number 2 had entered into with the respondent number 6 pursuant to the settlement order dated 4/11/2020 para. The events leading to the challenge made above as the events prior,
I find out another IA, my lord. Another IA I find out, my lord, filed by me, my lord.
but
1501.
that has gone with the
Yes, my
wind.
lord.
That was on 16/12. Nothing. Interim order passed earlier to continue.
Worship, all the writ petition and IA was
I was there
here, my.
hanging.
Yes, my.
I was there hanging with the writ petition.
Yes, my.
Right. But it has not come down to ours. It was all along hanging with the closure of the writ petition with liberty to the petitioners to challenge the new process. It merged with the interim order merged with the final order with no challenge to the order dated 8/4/2020. That I could gather with my limited knowledge.
This,
And it was
in this
withdrawn
IA, my lord,
with the liberty with eyes open.
in this
That
IA,
can
my
only
lord,
be,
this IA may be called for, my lord.
no, not required. No order has been passed. Why should we?
If, in this
We
IA,
are satisfied with the materials on record now.
in this IA, my lord, order was under challenge.
As so and so, and a number of litigation in the form of writ petitions were initiated by the petitioner Hein and other parties, it would be opposite to refer to the relevant and prior events, only the relevant and prior events which are necessary for adjudication which are necessary to deal with the issues raised and involved in this writ petition. Full stop. Para. On 12/2/2021. Is correct or not? Okay. A tender notice was published by the respondent number 2 inviting bids from eligible and interested bidders for settling the fishery via bill fishery in bracket the fishery F2 capital hobo along with via so and so district Hailakhan. Among 3 other fisheries. Full stop. In the tender notice, the minimum annual revenue for the fishery was fixed at 2,17,400. Full stop. In response to that was gone without any order. That was closed on that day without any order. That IA. Four bidders submitted their bids. Full stop. The bids submitted by the 4 bidders, including the petition, were evaluated by the tendering authority along with the bid values offered by them. Full stop. 1. Messrs. Ambedkar Pisciculture Cooperative Society Limited, page 30%, offered a bid value of rupees 44,01,000 as against the bid value of rupees 24,71,000 offered by the petitioner society for 7 years. One Mr. Sahabuddin offered a bid value of rupees 18,21,000 for the period of 7 years. Full stop. However, the highest, the petitioners, the society, the cooperative society, which is the cooperative society and Messrs. Ambedkar Pisciculture Society, withdraw their bid during the tender process, despite having offered the highest bid value. So stop after withdrawal of the highest bidder from the fray, the petitioner society emerged as the highest bidder. Full stop. Upon evaluation of the bid documents of the petitioner society and examining the complaint lodged by Sahabuddin, the tendering authority on 13/8/2021 passed an order of settlement in favor of the petitioner society. After finding the complaint lodged by Sri Sahabuddin as a baseless one. Full stop. Para. Holding the petitioner society as the highest valid bidder, the tendering authority settled the fishery in its favor by the aforementioned settlement order dated 13/8/2021 for a total bid value of rupees 24,71,000 for the period of for the 7 years settlement period. Full stop. The tendering authority, while settling the fishery, had further observed in the settlement order that as there were lot of complaints against the petitioner society, the tendering authority felt it necessary to direct the petitioner society to submit a bank guarantee equal to the revenue of the fishery for the period of 7 years. Within a period of 15 days before execution of the contract agreement for ensuring or preventing loss of revenue to the AFDCL. Full stop. Para. In view of agree by the direction to submit the bank guarantee made in the settlement order, the petitioner society submitted an application before the tendering authority, that is the respondent number 2, to revisit the settlement order dated 13/8/2021 insofar as the matter regarding submission, insofar as the direction regarding bank guarantee was concerned. Full stop. It was represented that such a condition could not have been imposed in reference to the terms and conditions of the tender notice. Full stop. Para. As the when the application to revisit the condition regarding bank guarantee was not disposed of within a reasonable time period, as the petition society found that its representation was not disposed of, comma, it approached this court by way of a writ petition, comma, WPC number 5606, 2021, raising an apprehension that due to non-submission of the bank guarantee to a settlement, comma, the settlement order passed earlier in favor of the petitioner society would be cancelled. Full stop. This court, while issuing notice to the respondents, comma, passed an interim order on 29/10/2021 stating that till the returnable date within bracket 22/11/2021, that the parties to the proceedings, said proceeding, should maintain status quo as on 29/10/2021. The purport of the, as a result of the interim order, comma, the respondent authorities in the AFDC Limited, more particularly the tendering authority, respondent number 2, more particular tendering authority stroke settling authority, was prevented from passing any final order on the representation application dated 28/9/2020. Full stop. Para. The bidder, comma, Sri Sahabuddin, agreed by the settlement order dated 13/8/2021, had, comma, in the meantime, comma, preferred another writ petition, comma, WPC number 5920/2021, wherein the petitioner society was impleaded as party respondent number 6. Full stop. This court on 10/11/2021 issued notice to the respondents, making the notice returnable on 22/11/2021 full stop. Para. in spite of the interim order, in spite of the fact that an interim order dated 29/10/2021 passed in WPC 5606/2021 was in currency, the settlement tendering authority stroke settlement authority, tendering cum settlement authority passed an order on 8/4/2022 upon consideration of the application dated 28/9/2021. Full stop. By the order dated 8/4/2022, the tendering cum settling authority, while recalling, while in the order, had observed that the condition of bank guarantee was not a part of the tender condition, and therefore, thus, the said condition was recalled. Full stop. However, at the same time, the tendering cum settling authority had reached a view that the order of settlement dated 13/8/2021 was not issued by taking into account the principle of commercial prudence. So as the petitioner society as the second highest bidder quoted a bid value much lower than the highest bidder, who subsequently withdrew the bid, the revenue payable to the AFDC Limited was not proper, was on the lesser side, and therefore the observing so, the settling cum tendering authority, tendering cum settling cancel the order of settlement dated 13/8/2021. Passed after initiation of a tender process by tender notice number 2/2021 dated 12/2/2021. Full stop. The order dated 8/4/2021, the tendering cum settling authority had directed for issuance of a fresh tender notice for settlement of the fishery. Monday will resume. Hemant? Oh, it will time it. Are Oh, it will. We put it on Monday. Let's see. Let us see.
At to logic.
Second half only. Second half. Second half you mentioned at 2 o'clock, we'll fix that time. I'll note down the facts so that the dates, otherwise it will be difficult.
Logic. I will note it down.
Mr. Release the case on Monday for further consideration. Further hearing.
Most to it. Okay.
You keep the records.
Logic.